Yes, welcome to the No State Project, live from the fortified compound in Mesa, Arizona. We are live here for an hour of Anarchy Radio right here on my YouTube channel, commercial-free as we are. It's episode 62 of the commercial-free edition of the No State Project. And I'm glad to be with you here. So glad to be with you here. This show, again, being brought to you by the generosity of our friends Bill and Dan in New Hampshire. Bill, of course, was the one that went through that horrible time with these criminals calling themselves the government of the state of New Hampshire, who admittedly didn't have a shred of evidence, but did what they were going to do anyway, because fairness and due process, yeah, those are buzzwords. None of that matters. None of it matters. So anarchy being, of course, the rejection of the concept of having a ruling class. That it's okay to lie, steal, kill, or cheat other people for no other reason than you call yourself a government. So, and before we get into everything here, I do want to offer my apology. I always, for my behavior on the last show, so we're going to have some new ground rules for the show, but I always talk about not falling for the stupid lawyer tricks, and I did. I have a mute button, and it's not for censorship. I'm not afraid of anyone who wants to call the show. I'm not afraid of anybody's argument. I have the mute button for a reason, and that is because when you're discussing these things and you're trying to answer someone's questions, having somebody incessantly interrupt you, which if you go to the broadcast, last week's broadcast, you can see that Juan Galt, he interrupted almost every thought that I had. And it's very difficult to keep your train of thought. I bent over backwards for this lawyer, who, by the way, doesn't think he enjoyed any kind of advantage because of the monopoly. Really, talk to the people that I have worked with and people who have wanted me to work and help them in court. I don't have that advantage that you had. You went and you put your arm to the square and you swore an oath, and you're part of the monopoly that keeps people like me out. So you were able to do what you did, whereas I can't do that. Okay, so you can say that, you didn't charge people. The fact is, people could go and they can engage your services freely. I don't know about free, but they can engage you in your services. Whereas people like you have fight every day to keep people like me from helping people. So you are part of the problem that destroys choice and takes the choice away. So to say that you didn't take and get a huge monetary advantage because you were part of a monopoly is disingenuous at best. But if you listen to the broadcast, you can see that he interrupted me incessantly. This is just a stupid lawyer trick. It's to get you upset. I've said it many times, so I always reference the movie A Few Good Men. You get somebody ticked off and they can't think properly. And I allowed that to happen after about 45 minutes or so. He just wouldn't shut up, and I could not finish a thought. And I apologize. I shouldn't have I bent over backwards for this guy. I am doing a broadcast, and on the Saturday show, I was actually streaming from LRN.FM, the Liberty Radio Network. And I made certain concessions because I got tired of always being accused of censorship. Well, you know what? Abba Fongul. I don't censor on the show. People can accuse me that. I don't care anymore. I am not going to make those concessions anymore. If you come on the broadcast, you have to be professional. If you cannot come on the broadcast and answer questions, if you refuse to stop talking and continuously talk over me, I'm going to use the mute button. If you still continue not answering questions or interrupting me incessantly, I'm cutting you from the broadcast. I am not going to put my audience, the people that are good enough to listen to this show, I promise, I will not put you through the nightmare that was my talking with a lawyer named Juan Galt. Well, we don't know his real name. Being open to dissent does not mean I have to be a friggin' doormat and that I have to tolerate somebody who won't answer a direct question And I blew through all the commercials just so I can give this guy a platform. So if he does call the show again, or anyone else, just like if you come on the show and you're irate and you start berating me, I'm just going to cut you. Being open to dissent, willing to hear you out, and have an adult discussion, a rational discussion, does not mean that I have to tolerate for a second your stupid little tricks of deliberately avoiding questions and deliberately trying to get somebody upset. And just know, I have a mute button for a reason. It is not for censorship. It is so that we can have a rational, honest, open discussion. And if somebody wants to accuse me of censorship, there's more than enough evidence now. If somebody wants to go through that show, in fact, if you go to markstevens.net, I clipped out, it was just too much editing to do, so I put the entire live stream, which is, of course, unedited. But I did take the as an MP3, just the one goal. And maybe what I'll do is I'll put that to a screen, just a static picture, and I'll put that up. So if people want to just go to the one goal part, it's easy enough. It's right there. So the evidence, unlike what Juan had, there's sufficient evidence that I do not censor. So if you disagree with something I've said on the show, then definitely give us a call. I had a prosecutor respond, and I'm going to do it. Hopefully I can get this posted to the show notes of this broadcast. The motion to dismiss, I get that lawyers disagree with it, especially prosecutors, because they have a vested interest in their system. Prosecutors, look, they're part of a criminal organization, and that's their job. That's how they make their money, okay? So if you point out the obvious, that even Juan Galt, when he eventually did answer, how does my physical location in Arizona prove the Constitution, a written instrument, applies to me? He said it doesn't. So when you bring out in the motion to dismiss that the prosecution doesn't have any actual evidence, even the prima facie, where this is one of the things Juan Galt got right, and I talked about this on the show. I even mentioned, I put it in a video. If there's any chance that the facts support the allegation, then a rebuttable presumption is created. Now, if my physical presence in Arizona doesn't prove the Constitution applies to me, there's no chance that fact can prove the allegation that the laws apply to me. There's no chance. So no presumption of correctness or no rebuttable presumption is created. There has to be some chance. And so what this lawyer did, now I don't have the name. When it got sent to me, I'm hopefully when he sends me the rest of the response, I will have the lawyer's name. And oh yes, I do plan on giving that lawyer a call. They used the phrase gobbledygook. A man with a Juris Doctorate, a man or woman with an advanced university degree referred to my motion that is written at a high school level or more of English that is easily understood. This lawyer didn't. It was gobbledygook. And this is what gets me about how arrogant lawyers are. And yes, Juan Galt, yeah, you, sir, are, yes, that the arrogance that it's not enough to just say his argument is wrong. No, you have to go and insult the guy, and you have to say it's gobbledygook. Imagine on cross-examination, and the prosecutor asks you a question. Where were you on the night of April 25th? Oh, that's gobbledygook. Imagine we responded to theirs. It's gobbledygook. I think the judge would be right to want to impose sanctions for responding that way. He's like, sir, you may disagree with what the prosecution has written here, but it's not gobbledygook. Oh, that's right. Rule 3.1. They may not argue unless it's based in fact and law. So turning around and saying that it's gobbledygook, not based in fact. Not based in fact. Gobbledygook. So to point out in plain English that the prosecution's argument that the laws apply because I'm physically in Arizona is unsupported, that the prosecution has gobbledygook, That's what you get for a $150,000 education. That's what you get. Just say frivolous at the top of your lungs, legalistic gibberish, and gobbledygook. Oh, I love how one tried to make a distinction. It's not English gibberish, it's legal gibberish. Ay vey. That means it's lawyers in their arrogance will not recognize plain English because they're so arrogant. This is why they're hated so much. They're so arrogant, they can't just say, sir, your argument's wrong, and here's why. No, not gobbledygook. We should start doing that. The prosecution is speaking legalistic gibberish. It's not making any sense at all. Oh, not English gibberish. No. Legal gibberish. That's different. So you just spin the word to mean whatever you want. Oh, really? Equivocate much? Yeah, equivocate much. Yeah. Oh, but one will tell you that basic principles of logic don't apply. Just like when, none of them. And nope. You can't use basic principles of logic in court. Really? Burden of proof is on the prosecution, the proof beyond a reasonable doubt. I guess you can't use basic logic in court because when it comes to the IRS proving their case beyond a reasonable doubt, they can't. So that's what happened today that JT was able to report to me about an IRS agent. Put on the stand, declared incompetent to make legal determinations, not judicial determinations, legal allegations or legal determinations. So even though the agent is under oath claiming that the laws create an obligation on somebody, even though they're claiming they have jurisdiction, which is not a statement of fact, which is a legal determination or a legal conclusion, and you can equivocate all you want, one gall, daba fungul, I don't care. We're using lay terms mostly here. They're making legal allegations. They're saying that the laws apply and give them jurisdiction. And yet, their own lawyer, the valiant U.S. attorney, objection, calls for a legal conclusion. The witness may not testify. Given now, again, let me just give a little more context. The agent has already testified under oath that the laws apply and that they have jurisdiction. All this man was doing was asking for the facts that determination was based on. The lawyer objects that it calls for a legal conclusion. Now, you can say, well, he's just a witness. No, he just made legal determinations. And the question was, and you'll go through this, everybody, if you're in court. We all go through the same thing. One thinks this is a valid objection. But when you ask him, what facts did you rely on to support the claim you just made that the laws gave you jurisdiction? What facts? All of a sudden, they're not competent to give legal conclusions, but that was not addressed. That's not addressing the actual question. What you have here is a stupid lawyer trick. What they're trying to do is use magic. They're going to redirect your attention away from the facts that you're asking for. What facts, Mr. Witness, what facts did the opinion you just made, was it based on? What facts? So the prosecutor is not making an on-point objection. He should be sanctioned. He should be held in contempt. They're not. So that's something that, thanks to how disruptive he was, I didn't have an opportunity to actually address. The question that they say the cop is not competent to answer has to do with the facts, not giving us another legal conclusion in his answer. So the day that a police officer or any witness can get on the stand and say that I'm the IRS or I'm the government and I have jurisdiction because the laws say so, the laws give me, to then turn around and not be subject to a challenge on that, you are in the rigged game. And to turn around and make an objection that's totally off point because you're asking for the facts. And that's something that happens in court, you got to bring up through an objection of your own. This lawyer is lying. I did not ask a question calling for a legal conclusion. He already did that. I'm asking him for the facts the conclusion was based on. So this nonsense that a police officer is just a witness. No, he signed the ticket as the complainant. Does it just magically disappear? He's writing a legal complaint Yeah. Someone's asking here, objection, didn't the witness make a legal determination when he stated the law applies to me because I was at the corner of A and front? Yeah, that's exactly what he's doing. That is exactly what he's doing. Right, because they're going to have, he says, well, anybody can make legal determinations and be a witness. Really? So when somebody says that A punched me in the face and I want to file a claim, they're actually saying he violated section such and such of the code? No, he's giving the facts. He says he punched me in the face. Maybe somebody, all right. So this is a very, very common lawyer trick. Most of what lawyers do, and one goal, you succeeded to a degree on my last broadcast, is to distract you from their lack of evidence. And so let me go through this again. This is very important. You asked the police officer if he determined the law applied and that he had jurisdiction because you're physically in Arizona. And they're always going to say yes. See, that now counts as prior testimony. He just said it. It also is on the ticket. It's a statement under oath on the ticket, which is the basis of the judge's determination of jurisdiction. So once he asked that question, and they'll always allow the police officer to make legal determinations if it makes, if it helps them. But the moment you ask that question, what facts did you rely on to support your claim? All hell breaks loose. That's when it all comes crashing down for the prosecutor because there is no evidence. So to go back to, even though Juan admitted my physical presence doesn't prove that the Constitution applies, therefore, and again, I have to finish it for him because he's just too dishonest to go and follow it. If there's no chance that the Constitution applies to me because I'm physically in Arizona, then there's no presumptive correctness or rebuttable presumption. It's just like with the IRS. The IRS, when they do an assessment, the law says they're entitled, they have now a presumption of correctness. But if you look what the courts have said, due process requires that it has an evidentiary basis. So once the IRS makes a determination that's based on facts, then and only then does a presumption of correctness arise, which can be rebutted and shown to be incorrect if the IRS has no evidence. Now, we've had the IRS admit that in writing. Michael Rakin, well, I'm looking at you, you piece of garbage, you. He's district counsel for the IRS in D.C. The judges won't strike it. See, that's the thing. It's not that it's creating a rebuttable presumption. No. Even though there's no chance that the Constitution applies. No, none of chance at all. The judges are not saying that there's a rebuttable presumption. These criminals are holding that the presumption is irrebuttable or irrefutable, which of course violates due process. Because it's a rigged game. Due process requires notice and opportunity to be heard, and that you have an opportunity to effectively defend yourself. And you can't do that if it's a irrefutable presumption. So that's the way they hold it. Man. Another thing is to address for those, especially for those who are new to the big broadcast. Juan kept on insisting that jurisdiction is power. I said, well, yeah, power to act based on what the Constitution allows. Now, somebody called me out and said, is it just what your naked assertion? Prove to me that just because, it's not just your say-so, Mark, that all jurisdiction comes from the Constitution. Well, if you look in the United States Constitution, all legislative power herein granted, it's by the Constitution. Article 3 for the courts, the federal courts, it says all judicial power herein granted, so it's through the Constitution. If the power being exercised is not based on the Constitution, is not authorized by the Constitution, then it's what the Supreme Court has said a few times, it's lawless violence. It's just naked aggression. So the question is, that is what led Juan to make his circular argument. Jurisdiction is power. I said, what, from the Constitution? He agrees it's from the Constitution. Well, how is the Constitution applicable? Because of power. So you have power that creates that makes the Constitution applicable? No. It was, and then of course he had to deny that it was a circular argument. That, of course, go back and listen to it. Of course he had to. Well, jurisdiction is power. Yeah, from the Constitution. Yeah. Well, this, like I wrote in the article, it's not a chicken or the egg kind of thing. What comes first? The power or the Constitution? Well, the only power that is so-called valid and constitutional is a jurisdiction that comes from the Constitution. If the power is what you're using to say the Constitution applies, you're not saying that the Constitution applies. Your actual argument is, your position is, the power is what gives us a right to do and a moral right to do it. The Constitution is nothing but public relations at that point. It's like I've said for 20 years. Wow, it's been that long. The Constitution is just to distract you from the power. So Juan Galt's position is no different than some of these other critics. Might makes right. That's it. I don't accept that. I reject that as immoral. Even he rejects it to a degree as immoral because he finally admitted that government is an immoral organization. And it is. Why? Because they're men and women and they force strangers to give them money. Criminal. So it is a circular argument if you are trying to say that jurisdiction is power, even though it's from the Constitution. And how is the Constitution applicable? Because of the power. You round and around and around and around you go, Walt. And anybody else who puts up that stupid claim, well, jurisdiction is power. Yeah. Isn't it from the Constitution? Yeah. How did the Constitution become applicable? What evidence? Because of power. You begin and you end with the exact same thing. That's circular logic. That's a circular argument. And this is what may or may not come up in court. To me, it's always just a matter of we have jurisdiction because we said so. That they're willing to hurt you. They're willing to put you in prison. But look, being willing to use aggression against me or anyone else, is that evidence proving the Constitution applies to me and creates obligations? This is something that we may have to say in court, but we should be going to these public meetings of county commissioners and city councils and bringing these issues up and making the moral argument to them. Bring out in front of all those people that they're a bunch of criminals. If I was to do things just like your organization, and I forced perfect strangers to give me money, would you consider me a criminal? You're damn right. You're damn right they would. And that's why they're a criminal organization. That's why there's absolutely no chance that their claims of personal jurisdiction have any validity whatsoever. And I don't know how many times we have to go through this on the show. Absolutely false to say that jurisdiction is a trial issue only and that it cannot be challenged at the pretrial level. And anyone telling you that is lying to your face, even if they are incredibly successful lawyers like Juan Galt. They're lying to you. Rule 12 is a pretrial motion. A motion to dismiss on the Rule 12B, for example, is a pretrial motion. I even put in the article ACLU versus NSA. And at the federal level, not so much at every state, it depends. But at the federal level, standing is absolutely a jurisdictional element. Now, in Arizona, its standing is very important, but it's not considered jurisdictional. I don't know why they don't make that distinction. It doesn't matter to me. But at the federal level, it is. And some of the states, it's not universal. Here, the ACLU was complaining about what the NSA lying about spying on all Americans and trying to have them held accountable for that. With the chilling effect that it has on newspapers and journalists. And they raised the issue of standing, that they had not shown standing to complain. And it got tossed out. They had to go up on appeal. And that's when the Court of Appeal said the first obligation of a trial judge is to determine whether there's sufficient facts to set forth a valid cause of action, and that the court had jurisdiction, had subject matter jurisdiction and personal jurisdiction. And they ultimately upheld the trial court's determination that there was lack of standing, meaning that there was a lack of jurisdiction. Now, did the NSA were they taken through the pretrial procedure as far as discovery? No. Were they put and was it at trial? No. Could they have shown that there was some possibility? Yeah, but they still threw it out at the pretrial. So this thing, trial, jurisdiction's trial issue only, abafungul, that's not true. Someone explained to me all these pretrial motions. You have motions to quash an indictment. That's a pretrial motion. And so the issue of personal jurisdiction, not the same thing as subject matter jurisdiction, but certainly related, because it all comes down to a written instrument called the Constitution. Personal jurisdiction hinges on whether it's true, or even if there's any chance that it's true, that just because you're physically in Arizona or Texas or Canada, any possibility that if you're in Texas, the Constitution applies to you. Any. I concede that. I'm not afraid of anything like that. I've even put it up here in my own videos. No big concern. My thing has been through 20 years of experience, whether in court or out of court, whether it's administrative, whatnot, what doesn't matter, and not all sorts of agencies, that not one single agent who claims that the Constitution and laws apply and give them jurisdiction, not one of them could produce any evidence to prove that that's true. None of them. And just, again, even one admitted at least the one time, your physical location doesn't prove that the Constitution applies. So if there's no chance that the Constitution applies just because I'm physically in Arizona, you cannot prove personal jurisdiction. You can't. You cannot prove personal jurisdiction. And if you think you can, man up, call the show, 218-632. Man, no one's calling today. 218-632-9399. Passcode is 2020. And saying that power, or in this case, it's actually aggression, the willingness to use threats of violence and actual violence, that is not proving a written instrument applies. Just, it doesn't. And if you think that physical violence and threats make written instruments apply to people and create obligations, you've got problems. And if you think that's moral, gosh, I hope I never have to meet you in person. I tell you, you're not the type of person I want in my life, because there's something wrong with you. There is something way, way deeply wrong with you. So to get back to this, if we're in court, we've got a lot of people, apparently going in this week. Don't fall for the lawyer trick. That's why I've said so many times, one of the most difficult things is being in a stressful situation like that, having these people deliberately be off point, deliberately interrupt you to get you frustrated so that you take your eye off the ball, so that even if you just get flustered and all of a sudden your whole train of thought is gone. That's what they want. We know that they're criminals because they force other people to give them money. They are criminals from beginning to end. And you have to be aware of that when you're going into court. And this idea that you and I can be forced by a group of robed criminals, we are not going to challenge what they're doing because it's not a rule that they allow. Abafungul. You don't force people into court or force them into a proceeding and expect us to then turn around and lick your boots like Juan Galt probably did and play by only your rules. You call them out. Our job is to call them out and make what they are doing so unbelievably difficult that they can't take it anymore, that it's so grossly unfair, they have to throw it out. It is absolutely nonsensical or gobbledygook to say you could be forced by a group of criminals into a proceeding, into their home or into their building, and that they're going to hand you a set of rules and say, you are forced to be here, sir, and you're only going to go by these rules. Fungal. That is what the weak-minded would do. That is what somebody who is complacent would do. That is what somebody who doesn't want to ruffle feathers. That is somebody who wants to give the prosecution a free pass and then try to pawn it off as being a good defense. No. No defense should begin or end with giving the prosecution a free pass. That's not how we should be defending ourselves. And it's not why we've been successful. And yes, I'll be the first to concede. Some of these, they're looking at it and saying this is too much trouble. That's the point. We're trying to make it so difficult for them to maintain their pretense of fairness that it has to go. Now, a lot of them, unfortunately, have no shame. They don't care. They could not give a damn how dishonest they are. They don't care. Because even if it does get reversed, let's say they deny cross-examination, even if it's reversed on appeal, the black-robed scumbag lawyer is still going to go about their day doing whatever the hell they want to their next victims. And that's another thing. One, if you or anybody else want to be on the show, you're not going anywhere with any discussion unless, if you accuse me of being a scammer and having victims, you're not going anywhere unless you produce evidence of a victim. Tired of that crap. So to get back, if you are going against these people, assume every word out of the prosecutor's mouth and the judge's mouth is a lie. Your job is to object and ask leading questions to bring out that they are lying. And I want to address this other issue, that asking if the prosecution has met their burden of proof is asking for legal advice. You can equivocate all you want. You can redefine words to fit whatever stupid argument you want to make. But asking if the prosecution has met their burden, the judge has made a determination of jurisdiction, which is why you are there. You're asking if he's met his burden so you can adequately defend yourself. You're not asking the judge for advice on how you should defend yourself. We're bringing out without having to ask, because it's implied. The judge already thinks that the prosecution has met their burden. We just want to know if that's the case. Legal advice. That is what you do when you have no argument. Oh, it's just legal advice. Oh, next time I'm on cross-examination, I'll use the Juan Galt line. And if I'm being questioned. Oh, you're asking for legal advice. License and registration, peon. Legal advice. I don't have to answer. Legal advice. Or I could just say, oh, I know the IRS is one. Cop asked me for my license and registration. Whoa there, tough guy. Whoa. That is a frivolous argument. I have it on good authority because so many U.S. attorneys have done that. So if you are in that situation like you're at in arraignment, the common lie is that they're only there to take a plea. No. If you file a motion to dismiss, that technically has to be determined prior to any plea being taken. So yeah, if you are objecting to the proceedings and you're objecting and pointing out that the prosecution has no evidence to prove personal jurisdiction for one, then that has to be addressed. So, all right, we have a call. So, we'll get to a call here. We have Ray from Baltimore. Welcome back to the big show, Ray. What do you got for us today?
Hey, Marc. This is Roy from calling from Baltimore, Maryland.
How's Baltimore today?
Cloudy and kind of rainy, but all is well. I called. I don't have a problem with a bureaucrat right as of now, but I'm called to give you much respect because what you're saying is very true. Because I took your advice a while ago, and I started calling district leaders, and I asked them the question like it's presumed that just because I'm physically here in Maryland or in Baltimore that the Constitution and codes apply to me. And if so, like if you have any evidence to prove that, they can't prove it. I get ad hominem attacks. They be very dismissive. They say I'm being argumentative, which I'm not. I'm just asking a question of fact. And I call prosecutors, I call attorneys, and nobody can just seem to answer the question. They direct me to the law library, and I asked the librarian the same question. And she said, like, "Are you a citizen?" I said, "I have a sworn allegiance to a body of politics for duty of protection." And she said, "Well, you're getting it somewhere in law and science." I'm like, "What the hell is that?" And
well, but you don't answer the question if they say you're a citizen, because whether you're a citizen or not hinges on whether there's evidence proving that the laws apply because you're physically in Maryland. I like this, this ad hominem. That's very common. It was probably more so accurate to say that they were insulting you, that they weren't using an ad hominem, because you were just asking a question. You weren't actually presenting an argument that they were then trying to defeat. So I'm sorry for splitting that particular hair. But do you have the names? Did you record any of this?
Well, I don't have the I don't know how to. I don't know the proper app to download to record any of my conversations, but I can pull up the one name is Samuel Rosenberg or something. He's a district for Baltimore City, for the 41st district. And when I talked to him and I asked him the same question, he said, "Well, the people got together and they decided." He kept giving me legal opinions. I said, "I'm not asking for legal opinions or opinions of lawyers. I'm asking for facts." He said, "Well, the people, they got together," and he kept repeating the same thing. And he was like, "And that's the fact." I'm like,
well, but Roy, it's Roy, right?
Yes, sir.
Yeah. The thing is, when people say, because I had a critic come on a few weeks ago, and they were insisting that the people got together and did that. And so you want to ask a question, ask your leading question. Are you talking about the people that were all forced to pay and support? Okay. Because that is something that people want. They want to look at. Well, the people voted for the federal Constitution, and that is actually true, but it's not complete. A certain small percentage of white landowners, male white landowners, voted for the federal Constitution. They weren't voting for whether they were going to have a federal government, though. So, there's a huge distinction there. And unbeknownst to this Sam Rosenberg, at least like for Maryland, not even a white male landowner voted to have the Maryland government in 1775. Even back then, nobody voted. Nobody was allowed to. So the people... it's grossly historically inaccurate to say that the people got together and created the government. That's just totally wrong. But what was his position? Oh, please, just Mark. What was his position?
He's a delegate leader for. He's a delegate for Baltimore City, 41st district. I haven't got the details, but
okay.
I can email you. His page.
Sure. Yeah, that would be pretty cool. Did you ever get a chance to ask them, if I did things like you and I forced strangers to give me money, would you consider me a criminal?
No, I haven't got to that chance because every time I try to get to that part, they hang up the phone. I don't want the phone.
Yeah. The last time I got to ask that question, it was for the court administrator for Tarrant County in Texas. And he said, I actually have to get that online. I have to still do that. I apologize. And he said, oh, that's a loaded question, and I'm not going to answer it. It's called a leading question, and you can say yes or no. But the thing is, either way he goes, he doesn't get out of the, if he says that, no, he wouldn't consider me a criminal, now he's got to explain. Really? So I can just force me, I won't be yeah, well, I don't, but the state might. So yes, you could always weasel your way out of a question like that. But if they're being honest,
Mark, and I called one attorney office and I asked the same question, and the lady said she has no idea. I forgot her name, but she said that's a good defense. And I started breaking it down to her, and I gave her your website, because she's like, wow, like this is real good information. So I gave her your website. So I don't know what she's going to.
Well, hey, I applaud you for doing that. And since you've done it a bunch of times, you probably are comfortable now going to a city council meeting and confronting them directly there.
That's my next plan right there. Because
nice.
they asked me, like, what are you trying to do? I was like, well, I watched one of your videos where you address the city council with your camera phone, and you want to pull the judges from their hollow halls where they can't yell and scream. So I want to do the same thing. So man, that's awesome, because like you make perfect sense that to all the trolls out there that's listening, shut the hell up. This Mark knows what he's talking about. So if you out there making assumptions and don't have no evidence, just shut up and go away. This man speaks the truth, and I'm a witness to it because I'm doing it myself, and I'm getting the same results Mark is. So just go somewhere and go sit in the corner. So
just to be clear, you are getting you're doing asking the same questions, the same leading type questions, and you're getting the same type of responses from lawyers and bureaucrats.
Yeah, lawyers and bureaucrats, same type of responses. Insults, dismissive, very dismissive, don't want to answer their questions, and hang up the phone on.
Yeah, I'm looking forward to it. And let me know when you're planning on going to one of the city councils. It doesn't have to be Baltimore, but it could be one of the smaller areas so you actually get a chance to speak. And what you want to do, Roy, is find out in advance if it's the type like in Tempe, Arizona, where they will answer your question. Don't necessarily do it like in Scottsdale where they just sit there like rocks. Well, we told you, Mr. Stevens, this is just public comment. It's not. We're not required to answer. So those are okay for training especially if you're going to court, so that you're working on your presentation and interacting with these criminals. But you've already gotten past that point, which cool. So get to one where they will answer questions and definitely have somebody go with a good camera, so that I'm happy to post it on my website and on my channel.
No problem, Mark. All right, Mark, but I just wanted to call and tell you that, man, and you made a believer out of me, so and everybody that's listening, follow his steps. He laid the blueprint down, so just follow it. So, but Mark, you have a good day, man, and everybody listening, have a good day. Do your role plays. You got a court date, do your role plays, keep up on it, and let's give these criminals hell.
Hey, appreciate the call, my friend, and looking forward to seeing some video from you.
No problem, Mark.
All right. Roy in Baltimore. I know I had that wrong before. I appreciate the call. And it's not a difficult thing. The tactic that we're using is rooted in basic logic. And you want to use that in court because you're trying to show that what they're doing is unfair. This is not like we're trying to use basic principles of logic and go into a medical situation like Juan tries to say. We're talking about just if you want to get through this, I don't know what the word is, this kind of mysticism that surrounds this mystery that lawyers have tried to build, that their hallowed halls are so honorable and whatnot. You know, the best thing to do to cut through all the crap that they're doing is learn basic principles of logic. So when one goal and people like that, these lawyers start saying that's not what advice is, and you could go, well, then now you're equivocating. All you're doing is equivocating. You're just trying to redefine words to fit your narrative. And I am a big proponent, I've said for a long time, when we call them, do not allow them to use words of art. Do not allow them to use weasel words. Don't allow them to dictate the narrative. Don't allow them to use equivocation or conflating things in order to avoid answering your question. Because when you go to court, when you go to these city council meetings, or you just call them on the phone, or you talk to a zoning official, that is what they're going to do. That's why I say that the most difficult thing that we're dealing with is the BS that these friggin' lawyers are going to spew. I don't have a difficult time talking to lawyers because I'm half retarded. I have a difficult time talking to lawyers because lawyers are so arrogant and so dismissive and have so much disdain for anybody who dares to enter into their hallowed halls without permission. I have seen firsthand, and there are many reports online where you can read this. Many examples. Gosh, I remember that scumbag in Phoenix actually got censored by the Arizona Supreme Court 20 years ago. This guy had I think it was an 11-1 jury verdict in his favor against the supermarket chain. 11-1! Did it all on his own. Took on one of the biggest, they're not around anymore, but 20 years ago, they were a huge store chain in Arizona and the West Coast. I think it was Smitty's. I think. But I know for a fact, I remember that clear, that it was an 11-1 jury verdict. And this piece of garbage judge threw out the decision. I saw the order. This guy was protesting for a while outside the courthouse in Phoenix. And he wrote on his order, throwing out the judgment, an 11-1 jury verdict. Oh, what a tangled web we weave, when unto a lawyer we fail to cleave. Abba Fungul and your family. That judge got censored, but he still had to appeal what the judge did. I don't remember if he got it, if he did get it reversed or not. I don't remember that. So I know the absolute disgust, because I've been there myself. Anecdotal. Yeah. We're talking about court, not science. It's all anecdotal. What the hell? What happens in law that is controlled for, like a scientific experiment where you could say it's not anecdotal? You see, this is what I'm saying. These stupid things that are said just to avoid answering the question. That you ask somebody to prove XYZ, that you did XYZ. You give him an example of that you did, and then he dismisses it as anecdotal. Because lawyers, as a group, tend to be extraordinarily arrogant. They don't like when non-lawyers come in. So what they try to do, is to try to keep this mystery that what they do actually requires a doctorate degree in order to do, which I'm living proof, and I've had many people on this show, are living proof. You don't need to be a lawyer to go and successfully prosecute a case or get a case dismissed. You don't have to be a lawyer. So I don't know how many times lawyers, with black robes on, have shown their utter disgust with me. And you can say it's because you just present gobbledygook. Well, all I have to say is fungul. If you have a problem with my argument, show me where it's wrong. And that's what we're doing when we're going to court. We're just showing where the prosecutor's claims are dead wrong. So to address this other issue, is it accurate for me and people who I'm working with to file a motion to dismiss for prosecutorial misconduct against the prosecutor because they argued and made a legal claim or allegation without evidentiary support? I believe it is. Also, it's not just prosecutorial misconduct because they're arguing without evidence. They knowingly put a witness on the stand that did not have personal knowledge of the matters they were testifying to. That's also prosecutorial misconduct. That's a serious Brady violation. Of course, the judges let it happen because, as Kaczynski said, prosecutorial misconduct is at epidemic levels and only judges can put an end to it. So when we get back, and we'll finish, maybe we'll finish on this, we've already established, and the prosecutor is not coming out and actually saying, I've never seen a prosecutor in court that I remember saying, we have a prison system, sir. Your Honor, we have a prison system. That's evidence the Constitution applies. That doesn't happen. They know they don't have the evidence. One Gold knows they don't have the evidence. Look, might does not make right. That is not proof. So when we claim that the prosecutor is arguing without evidence, it's because in a lot of cases, they're actually saying they don't need evidence. Okay, but the ethical rule says you do. Due process and fairness says you do. Oh, and here, basic principles of logic say you do. The burden of proof is on the one making the allegation. To turn around and say, I don't have to, you're just a crook. You're a dishonest crook. And that's why I have a lot of disdain for lawyers, because they are proponents of this garbage. They will actually go out and spend hours and hours going after somebody pointing out that it's unfair and making these ridiculous arguments that I'm wrong and that I'm a scammer. Oh, and another thing, when we do this and we go to defend ourselves and we point these things out, make no mistake. I don't ever hold myself out as a lawyer, so you can, don't fall this insult, a pseudo lawyer. I'm not doing anything resembling what lawyers do. I'm actually honest. Okay? And the people that I work with and those who have called the show and have gone in, and like Roy, who are making these challenges, we're not trying to be lawyers. We're trying to blow the system up, so to speak. We want the system abolished. The same system that grants lawyers a monopoly to charge insane amounts of money. I've been to my share of doctors' offices, and I've been to my share of lawyers' offices. Let me tell you something. Lawyers' offices look like palaces. The money that is spent, they only do it because they have a monopoly. And what they do is they're spokesmen for these disgraceful organizations, these criminal organizations called government. That's all they are. They're mouthpieces. To turn around and say that they actually, again, I'll have to end on this point. To say that that the fact that you're physically in Arizona, that together with the allegation that the laws apply and that you're physical, because you're a physical location, and that gives the court jurisdiction, to say that there's any chance that that's true and then creates a rebuttable presumption is disingenuous at best. And to turn around and project on me that I'm the scammer, no chance. No chance. You notice Juan's not doing a video trying to show that there's actually proof that a written instrument called the Constitution applies. He didn't try to do that. You're not doing that, buddy. Why? As I said so many times, it can't be proven. So if you are going against these people, yes, like Roy said, you got to do the role playing. You got to understand that you're asking leading questions to bring out contradictions to show how unfair it is. And here's the big question. Can you destroy a rebuttable presumption by asking questions or pointing out that the rebuttable presumption is improper because there's no evidence? Yes. Yes, you can. You do not need contradictory evidence to destroy or strip them of a presumption of correctness if the presumption of correctness was improper in the first place. See, strike the root, or the root. There's no reason to start trying to pile on evidence if they don't have proof to support it. Because right doesn't make right. And we're going to proclaim that every day. And that's part of our defense. I know I'm not saying we're directly doing a moral argument. I'm not saying this is wrong because it's immoral. It's accurate, but it's not what we're doing. We're bringing out the immorality, and that's the foundation, but it's not what we actually argue. We don't need to. Because it's immoral, they can't possibly prove that their laws apply. And because they can't possibly prove that their laws apply, there's no presumption of correctness. And if you want to persist otherwise, you have to show that there is a chance that your physical location proves the laws apply. And without that, your argument has no merit. Well, nothing to really, all his attacks or arguments against me have no merit. I mean, please. I think we may have actually set a record for the number of people listening live. So, hey, that's great. I say that. They start dropping off. All right, this has been episode 62 of the No State Project, live from the fortified compound in Mesa, Arizona. I appreciate the call from Roy and the work that he's doing on helping to expose these people, because that's what we're trying to do, expose these people so that enough people know that they are just criminals. They are just criminals with a prison system that, despite what lawyers say, they are still just criminals. They should be resisted, and they should be challenged, and they should be abolished. That what we're looking for is to have a society that is premised on morality and ethics, that the basic principles of right and wrong, of do no harm, live honestly, injure no one, give every man his due, apply to all. That's the goal that we are looking for. Again, my name is Marc Stevens. This has been episode 62 of the No State Project. We'll be up on markstevens.net. And until next time, salud.